Okay. So today, again, March 3rd, this is for the Wednesday night class. Just to kind of give you, again, as a reminder, don't forget that your exams are not cumulative. So everything that we've learned about in this first third of the semester, there may be some legal theories that kind of repeat themselves. You're going to see actually like undue influence and fraud creep into this next third and also the last third of the class, but it's going to be a different field altogether. Right now, the next couple of weeks, we're going to be concentrating on contracts. We're going to be going into detail, nitty gritty contract. What makes a contract a contract? How do you invalidate a contract? Who can enter into a contract? And so it's not that many chapters, but like basically, chapter 9 is like a general overview, and then we're going to go a little bit deeper in as the weeks go by, even I think today, because today we're going to cover 3 chapters. So it's, you know, I like the way that I have the class divided up is into those 3 segments where we cover all these different topics. The first third, the second third is just contracts, and the third third is you take the contracts, the stuff that you learned about contractual relationships, and now you kind of build upon that with businesses and business formations and things of that sort. So if there's any questions, obviously stop me. I am assuming that you've read, in preparation for today, like you're supposed to do, because the only thing I give you is reading. But again, it's going to be just contractual stuff. You're actually going to be taken in mentally less stuff this couple of weeks than you did the first third of the semester, only because the first third, as you could see, we covered a wide array of legal topics. So we were going from criminal to negligence to intellectual property to torts and things of that sort. So you learned a lot of different topics. The next few weeks are just going to be about contracts, but don't be fooled. Typically speaking, the second exam is where I see the largest dip in grades. Even though it's not that much material, it's, we go into a little bit more specifics. So again, if there's any questions, go ahead and ask. And that's pretty much it. Any
Professor, I have one last question.
Sure.
It has to do with the exam. If you want me to save it for later.
No, go ahead, ask it now.
All right. So there was a question. I'm pretty sure that I got this question wrong.
Okay.
Uh, it said some. I don't remember the name you used, but basically, a spouse wrote a will that her husband could only get $25, and she left behind $1 million for her children.
Right.
And I'm pretty sure I put 25. See, look, in the beginning, I thought it was like dumb. Like, no, like, how could she put 25? But then I kept second guessing myself and I put 25 and it came out wrong.
Yeah, that's wrong.
So I want to know, like, how do you determine that? Like, what?
Remember, the question asked, what is the most the husband can get? So don't forget, we spoke about if a spouse wants to disinherit another spouse, they can't do that.
Disinherit as in what? Like, in simpler terms, like, what do you mean?
Is if you leave them $25, that's basically disinheriting them. You're not giving them anything. That's like being, you
Okay.
know, like silly. It's just because if you remember, she gave him $1 for every rotten year that they were
Yeah.
married, right?
Yeah.
So that's not really a bequest. And so a spouse, if you had no will, a spouse would be entitled to the first 50,000 plus half. In that case, when it's $1 million, it's a tremendous amount. She's cutting him out. She's saying, I don't want to give you anything. I'm giving you this, like these pennies,
So
essentially.
what was the answer for that?
What do you remember? So if you're trying to disinherit a spouse, what can they get?
You said 50,000 plus half.
That's if there's no will. So if there is a will, what can they do? Does anybody want to help him if they remember, or have you taken the test so now everything's out of your brain? Yep, 333, a third. They can get up to a third. That's the right of election. And so
Do
a
we
right
need
of
to like know this for future exams?
Nope, you don't.
Okay.
Nope.
Thank you.
That's just for life. So, okay.
Thank
So
you.
now we're going to go into contracts, the wonderful world of contracts. What I like about contracts and learning about contracts and teaching about contracts is that you deal with contracts on a regular basis, whether or not you actually know it. Contracts are a part of your life. whether I'm sure you have all signed the contract. It doesn't matter how old you are. Right now, you're all above the age of 18. You've all signed contracts. You may not know it, but you've all agreed to contracts. You are all parties to contracts. And contracts are going to be, regardless of what you do in life, what your employment situation is, where you live, you're going to be signing a contract, maybe even drafting a contract at one point or another. I want you to think right now. Give me an example, a specific example of a contract that you have signed to date.
Can I go?
Yeah.
So I work in a nursing home. So when the vaccine came out, they made me sign whether I wanted to take it or not. And if you vote no, because of in the beginning there was like a short, like there wasn't a lot of vaccines. They made me like double sign, uh, like to confirm that I know that this may be the only time that the vaccine is offered, and that I'm aware that they're offering it and stuff like that.
Okay. Um, okay. So what you signed was a contract.
Yeah, whether I wanted to take it or not. So you have the
Okay.
yes, obviously, and you have the no, and you have also the other one where that you were given a document saying whether or not you wanted to take the vaccine.
Okay. Somebody wrote also fitness club subscription. Yep, absolutely. What else?
Would like financing something count as that would count as a contract, right?
Absolutely.
Right.
Absolutely. Yep.
Yeah.
I know when you go skydiving too.
Wait, hold on one second. David, hold on. Jessica, go ahead.
Isn't it like every time you agree to like a terms of service agreement on like Facebook, that's technically
Yep.
a contract as well?
Exactly. Yeah. Every time scroll through the terms and agreements on a screen for an app or for a purchase of a new phone or for any new electronic device you get, you scroll, you scroll, you scroll, you check off yes so you can move on. That's a contract that you just signed. And so it's important to know the relevance or the impact a contract can have on you. And so most people don't read these long contracts, right? Because they're too long. You want to use the app or you want to have the phone or you're going to just sign off. But what happens if there's a problem? What are your remedies? Your remedies are actually written in the contract if you ever read it. It tells you if you have a problem, what you can do. So it's important to always read contracts. I mean, I'm a big, big, big proponent of reading that nitty gritty, fine tune things. When we bought like our first place that we lived in, it was a condo and it was newly built. And so there was a whole big book that we had gotten from the builder about warranties and things of that sort. I went through that with a highlighter and a pen, and I highlighted everything that we needed to know. The important things. What do we have our warranty on? When is it going to work? When is it not going to work? Most people don't read it. And so if you don't read it, you don't even know what you're entitled to. You may be missing out on a lot of they're not even perks, things that you're actually entitled to. So if you don't read, you're not going to know. And don't rely on somebody explaining it to you, because somebody can explain something to you, but they can leave a pertinent part out. And when you sign a contract, there's usually a clause in there that says, my understanding of this agreement is in this document. There's nothing else outside of this document that I relied on in order to sign this thing. So I want you to kind of have that understanding, that background information before now we kind of get into the specifics of it. And generally speaking, when we talk about contracts, there's two different types of contracts. There's the business to business contract. So it's when two business entities are dealing with one another. Those are commercial contracts. And then there's the business to consumer contract. And that's when a business is dealing with a consumer. So it's the telephone company dealing with you as a consumer. And there is, this is all like listening, not write it down moment yet. In 2012, there was something called the Restatement of Law for Consumer Contracts. There was no real way to unite or have a codification of codes. Whereas, in criminal law, when we talked about the definitions of things, you had specific definitions of what murder is, you had specific definitions or statutory elements of assault and battery. With contracts, it was like, one entity would kind of have this outcome, another jurisdiction might have this particular outcome. It was kind of like all over the place. So there was a push to kind of try to unify it or have some kind of code where people can use as a reference. That way people would know how to act when they were entering into a contract. And that's when the UCC, the Uniform Commercial Code, was kind of born. Article 2 of the Uniform Commercial Code governs the sale of goods. It governs the sale of personal property. And it governs, when you're passing title from one person to another for a particular price. So when we talk about goods, we're talking about tangible personal property. So that should ring a bell, right? When we talk about tangible personal property, that bells should be going up. It's like, oh, I know what that is. And that's, goods are that tangible personal property. When we're talking about the sale of goods, we're talking about the sale of the phone. We're talking about the sale of the pen, the cups, the furniture, all that jazz. So how do you know, or how do you enter into a contract? The guide is, you can look at that Uniform Commercial Code, and there are some things that actually define, these contracts. A contract, when we talk about a contract, again, generally, it's basically just an agreement that's binding that the courts will enforce. And I tell you that, keep that in the back of your mind, because you're going to see that there are sometimes exceptions. So a contract I'm going to ask you with a show of hands, whether you want to show me your real hand or your fake hands. Can an oral contract be enforced in a court of law? Yes, hand. Okay. How many people say that an oral contract is never enforceable? Okay, I'm glad nobody raised their hands, right? Because an oral contract can be enforceable, but it depends on the terms of the contract. There are some ways, some avenues or some situations where an oral contract can be enforceable. If you and I wanted to, if I wanted to sell you my pen for $10, do we have to draft a contract for that? No, we don't. It's minuscule. So oral contracts are enforceable up to a certain monetary amount. If it's under $500 or $500 is the max, then that can actually be done just by a verbal agreement. Why do I recommend putting things in writing? Based on what you've learned so far.
Because there's proof.
Yeah, there's proof. You have proof, and not just because like maybe you don't trust the other side or whatnot. When you have something in writing, you can refer to it, right? And we've talked about this before. I don't remember what I did yesterday. I don't. So how am I going to remember the details of an agreement I had with somebody over the sale of a particular item? I'm probably not. Maybe there's something that I forgot. When you start writing things down, you may actually come up with questions on, well, what happens when this happens? What happens if X happens? What happens if Y happens? Do I have to give you this payment by this date? Well, what if I can't pay you by this date? An attorney's job is to try to kind of present you all these different situations so you can think about it and then kind of present it to paper. A contract in its simplest form is really an agreement between two people or more, where they want to get into a particular relationship. One side shouldn't want to screw the other side. It should be a give and take. This should be like, I want to work with you. I want to get into business with you. I want to sell this from you. I want to buy it from you. So both sides want something. Each side wants something from the other, and they're now kind of just negotiating those terms. This is something I like to tell people. It's gonna blow your minds, right? This is a write it down moment. All contracts are promises. All contracts are promises, but not all promises are contracts. Not all promises are contracts. So I'm gonna repeat it one more time. All contracts are promises, but not all promises are contracts. There are promises that have no legal remedy. And so if there's no legal remedy, or there's nothing available for breach, it's not really a contract. So when two people actually enter into a contract with one another, let's say it's just for the purchase of this phone, right? I promise to sell you this phone. Or I'm going to sell you this phone, and you say I'm going to buy this phone for $500, $200, $300, whatever it is. We're kind of getting into an agreement with one another. If I say I promise to sell you this phone at some point in time without any definitiveness to it, you know, I'm going to think about it. I promise I'm going to think about it. There's no contract there, right? The example I like to give is, it's better, and this is, you know, you'll probably laugh, but it's better to actually tell someone, I will love you for the next 2 years. I promise to love you for the next 2 years, rather than say, I promise to love you forever. Because forever is an infinity. There's no definitiveness to it. But if two people say to one another, I promise to love you, protect you, and honor you for the next 1 year, and then we'll kind of reevaluate the situation, that is more of a contract than to say, I will love you until the end of time. That's not possible. That's not possible. That's not a contract. So that's a promise. That is not a contract. So you kind of want to keep that little, like, you know, tidbit in mind. In order for a contract to be enforceable or to be recognized by the law, there's these 4 things that these are the 4 basic requirements that must be in a contract. I'm going to tell you what each one is. I'm just going to give you the words, and then I'm going to define each one. And I'm also going to tell you, like, I'm going to speak about it briefly now, but each of the chapters that you're going to be reading, each like chapter focuses on one of these elements. So again, I'm going to give you a general overview now, and we're going to be talking about it a lot more, you know, today and over the next few weeks. So the 4 basic requirements in a contract are: number 1, mutual assent. Number 1 is mutual assent. I'm going to define them later. Number 2 is consideration. Number 2 is consideration. Number 3 is legality of object. Number 3 is legality of object. And number 4 is capacity. Number 4 is capacity. Again, this is all in your textbook, so I shouldn't be saying anything that's blowing your minds right now, because this is all, you know, in your book. So let's go back to number 1, mutual assent. Mutual assent is basically the two parties that are entering into this contract, either by words or through conduct, they basically agree to enter into a contract with one another. The way that that's shown is through offer and acceptance. We're going to talk about that also. So when you make an offer and somebody accepts it, that is that first component, mutual assent. Both sides have a mutual understanding of what they are agreeing to. Okay, that's mutual assent. Consideration. Consideration is the kind of give and take. So each person has to have either a legal benefit or a legal detriment. And the way I like to explain this in English is, let's say you and I are entering into a contract for the sale of my phone. I have the phone. I'm going to lose the phone. I'm going to have a legal detriment. I'm going to lose that phone. What am I going to get in return for the phone?
The money or the agreed upon benefit.
Right, money. Now, what do you get?
The phone.
The phone. So you're going to lose out. Your detriment will be your loss of money, but your gain, your benefit will be the phone. Mine will be the loss of the phone, but my benefit will be the money. So each side has to get something. That's why gifts are not contractual agreements with one another, because when you give somebody a gift, you're giving them something without expecting anything in return, right? So that's consideration. It's the give and take. I get something, you get something. I get something, I lose something, you get something, you lose something. That's that consideration. Legality of the object. I think that's my favorite out of the 3. Whatever you're contracting over, it's got to be legal. If it's not legal, you can't enforce it in a court of law. So if you are going to enter into an agreement with somebody for the purchase or sale of drugs, and they don't give you the drugs that they're supposed to, let's say you contracted for, you know, I don't know what people are buying these days, heroin, coke, weed, whatever it may be, and you wanted to buy a pound, half pound, whatever the metric system that's used of it for $100, and instead of getting whatever the drug was, you got, let's say if it's weed, something green, basil, or, you know, whatever. So you got that. You can't go to the court and say, oh, excuse me, judge, I entered into an agreement to buy a pound of, you know, weed, but instead I got a pound of, you know, whatever, something that looks like it. So it's not legal. You cannot contract over it and expect that a court will enforce that agreement. Okay. The last one is capacity. Capacity should ring bells to you. In order to enter into an agreement, the two people need to have proper mental capacity. It doesn't mean that they both need to be brilliant. It doesn't mean that they both need to like understand all the intricacies of the law, but you cannot enter into a contract with somebody who's under a mental disability. You cannot enter a contract with a minor. There's caveats with that. But there has to be proper mental capacity. Again, think about the underlying, you know, essence of contracts. Two entities want to get into business with one another. There's a give and that take. So they both have to be on that same level playing field. Okay. So anybody have any general questions? We're going to get into a lot more detail about this. This is just a general overview. Everybody okay?
I was actually going to say, what exactly is an adjudicated incompetent? Is that just somebody with a mental disorder? Because
No,
then there's
adjudicated.
incompetence versus.
Yeah, when we say the word adjudicated, it means that a court, an entity of power or authority has documented them that they are in fact mentally unstable, intellectually disabled, or something like that. So usually when we say adjudicated, meaning a court has deemed them, you know, incapable of making these decisions, or a medical facility has deemed them not being able to. But usually from a legal perspective, a court has to say that this person can't make decisions for themselves.
Gotcha.
So when we talk about a contract, right? Generally speaking, it's got to be enforceable in order for you to be able to bring it to a court of law, right? You want to be able to say that, well, I want to be able to enforce the terms of this agreement because I expected X, Y, and Z, and I didn't get that. So like I said before, oral contracts can be binding. They can be enforceable as long as there's no, again, undue influence, there's no duress or anything like that. The first case, it's like a baby case. It's not over too much money, right? But it talks about one of the aspects that we just discussed. I don't want to ruin it. Who wants to tell us about Steinberg versus Chicago Medical School? Go ahead, Jessica.
So basically, Steinberg had submitted his college application for $15 to Chicago Medical School. He was rejected and then sued them on the basis that they judged him on non-academic criteria, such as him not having good family connections, not having made donations. Meanwhile, it had stated in their bulletin that they will properly consider all candidates. So that was their promise to him, and he had, I forget what the term they used was, but like had actually considered it by giving them the $15. I believe it was initially dismissed, and then it was remanded for reconsideration because he appealed, in which I think they actually did stand by him.
Absolutely. Yeah, excellent. You got it right on all points. Okay, I'll get to you, John Davis, in a second. Capacity is the mental ability. Okay, capacity, mental ability. So Jessica hit all the right points. In this case, medical school, Chicago Medical School, had a posting. They stated they were going to look at A, B, C, D, E criteria when evaluating whether a person can be admitted to their medical school. So Mr. Steinberg paid the $15 and applied. They accepted his payment. But then after they accepted his payment, they rejected him because they were looking at criteria that was not actually posted, like your family background, your family history, how much money your family had paid, your legacy, things of that sort. So he had entered into an agreement with them by him paying that money, by the school accepting it and cashing it. They entered into an agreement with one another. They basically had this offer of, we will review your application, you will be considered because these are the things that we're looking for. He applied based on that premise, but he was denied because they were looking at other things that were not disclosed. There has to be a meeting of the minds. If they had put down on their initial bulletin or advertising that they were looking at A, B, C, D, E, F, and G, and they were considering F and G, and then he applied and then he didn't get in, that's okay. There's no problem there because he was made aware at the onset. He was given notice of the criteria that they were looking at, and he decided to apply nonetheless, regardless of whether or not he had a shot. So that's Steinberg versus Chicago Medical School. Very good, Jessica. The next section of the we're going to kind of talk about is, there's a lot of different ways to classify contracts. So, in the beginning of today's lecture, I kind of talked to you about, well, there's commercial contracts and then there's consumer contracts. There's a lot of other ways that we can talk about contracts. I'm going to go over 3 out of the 4. So I'm going to write the ones that I want you to know in the chat, and then we're going to go over them. Okay. So I want you to know and understand, and we're going to go over it, the difference between express and implied contracts, the difference between bilateral or unilateral contracts, and the differences between valid, void, voidable, or unenforceable contracts. So when we talk, and so it's not, an express contract can be bilateral. Okay, an express contract that's bilateral can be valid or can be void. So it depends on those are just different ways to classify contracts. Okay, so what's the difference between an express and an implied contract? What is an express contract? Give me a specific example in your own words, simple things of what an express contract is.
Like you say, someone asks you if you're selling something, you say yes, this much money, and then
That's
they
an
agree
offer
to
and
it.
acceptance. Yeah, exactly. As long, yep, if they agree to it.
They agree to it. They're expressing physically or
Yeah,
verbally.
that's right. So they're saying basically it's clear. This is my phone. I'm selling it for X amount. Okay, I will take your phone. It's clear. My phone for this much money. So can you give me an example then, whether it's Carmen or somebody else, of an implied contract?
The only thing I can think of is the example the book gave about like a customer in a store
Mm-hmm.
who if the store clerk had like a rapport with that customer
Mm-hmm.
and they had an account with that store, the customer might walk by, hold up an item they're buying, and just walk away. And then the clerk would know that that just goes on their account.
That's a good example.
Yeah, it's the only thing
Or
that comes to
yeah,
mind.
no, that's fine. Can you think of anything else? Anybody? An implied contract? What if I hire you to paint my house? If I hire you to paint my house, would you then also be able to imply that I'm going to tell you what color I need? Perhaps buy the paint or whatnot? Like if I hire you to paint my room, and we agree on a number, like, all right, I'm going to pay you $100 to paint this room that I'm in. It's also implied I'm going to give you some more information, like, hey, this is the color that I want, or I want you to start on this day, right? So yes, we're going to agree to service of some sort, but you're going to need some more information. But you can imply that eventually I'm going to provide you either more information or whatnot. So an implied contract can still be valid. It's just not as express. It's not as clear. Whereas an express contract, both parties, both sides, their intent is crystal clear, what they're looking for, and that can be done through words. It could be done in writing. It's fine. When we talk about an implied contract, it's usually not in writing. It's usually either the conduct or the circumstances can lead somebody to assume that a contract does exist. Okay, so the next thing is bilateral versus unilateral. Okay, this usually sometimes can get a little tricky, so I'm not even going to ask you what your understanding is. I'm going to
Actually,
kind of just,
I don't think this is like really that tricky, to be
okay,
honest.
so tell me, give me an example. Tell or explain the difference between a bilateral and a unilateral.
Well, I know I was gonna just say like the bilateral part, like what is it? Um, the bilateral is basically I tell you I'm gonna do something, but in exchange, you tell me I'm gonna do something for you, you do something for me, and we both come to that agreement. It's kind of goes back to consideration, like a give and take.
So what's the difference between a bilateral and a unilateral?
I don't the unilateral is I'm confused about, but
Okay.
I thought you
Uh,
just wanted the like an example of bilateral.
I was gonna explain both so I can distinguish, but somebody wrote a bilateral is usually where services are exchanged between both parties, I think. It's a little
unilateral.
bit more than that. See, when we talk about a bilateral contract, we're saying that both sides, each side is a promisor and a promisee. Each person makes a promise and receives a promise in exchange. Because remember, we talked about contracts, right? All contracts are promises, but not all promises are contracts. So in a bilateral, each side is making a promise. So I promise to mow your lawn. I promise to mow your lawn on Saturday. You promise to pay me $15 after I mow your lawn. So I'm making a promise to mow the lawn. You're making a promise to pay me. What if I were to say, if you mow my lawn, I will pay you $10? How
would
is that
be
different? Yeah,
that would be unilateral because you're not engaging in, not both parties are engaging in a promise, only one is. That
exactly.
the party that is being offered to mow the lawn doesn't have to mow the lawn.
Exactly. When I say that if you mow my lawn, I will pay you $10, great. It's a unilateral contract. If you mow my lawn, I'll give you the $10. If you don't mow my lawn, there's nothing between us. There's no contractual obligation. So if you do it, I'll pay you. If you don't, there's nothing. But in the first example I gave you, I said, I promise to pay you, I promise to mow your lawn, I promise to pay you $15. It's both sides are promising to engage with one another. It's not just one side promising to act. It's not contingent upon one person acting. Whereas with a unilateral, it's contingent upon one person acting. Then it's going to determine whether or not the other side will fulfill their part. Does that make sense, or you want me to say it again? In my head, this is clear. So because I know this stuff. So, you gotta kind of speak up. Make sense? Okay. So again, to clarify, to make it crystal clear, a unilateral contract, it's one party making the promise. Whereas with a bilateral contract, both sides are promising to do something. So another example, back in the day when we used to be in class, if I was to say, I'll pay you $20, over express and implied. Yes. Okay, David. When I'll pay you $20 if you give me a ride home. I'll give you $20 if you give me a ride home. What's that?
Unilateral.
Unilateral. Yep, exactly. Because I'm gonna only pay you the money if you perform this particular act. If we were to say, I'll give you $20 if you drive me home, and then you say, okay, I'm going to drive you home. So I'm not using the words promise, but you can see that both people are now making commitments to one another. It's not just one-sided.
So language is real important.
Very, very important.
And that
That's
could
why
be twisted.
Yep,
easily.
absolutely. That's
Okay.
why it's important to put things in writing. Because language can dictate different things, and you'll see as the next few weeks go by that what one person can say can be interpreted in a different way, and that's why you want to get as much clarity as possible in a contract.
So go back to, basically don't make promises you can't keep.
Yeah, absolutely. Because somebody can rely on that. And if somebody relies on that promise, you may be legally obligated to perform, your end of it, even if you didn't really mean it. So I'm going to go back to express and implied. Okay, express is a crystal clear agreement where both sides, either through words or through writing, are agreeing to do X, Y, and Z. An implied contract is, it may not be so crystal clear, but the circumstances can dictate that a contract is expected or that a contract is actually there. Okay? Okay. So those are the differences between express and implied, bilateral and unilateral. The next section that we're going to go into is, actually, let me see if this also promises one promise for that. Okay. So the next thing we're going to go into is valid, void, voidable, and unenforceable. Okay, a valid contract is a contract that has those 4 elements we spoke about earlier. That's what a valid contract is. So it has the consideration, it has a mutual assent, it's got the legality aspect, and everybody's mentally able to enter into one contract with another. So that's a valid contract. It's all good in all those 4 things. When we then talk about the others, then that's when we get into things that could perhaps be a little more dicey. A void contract, void, is an agreement that has no legal effect. It's not a contract at all. So if you were to enter into a contract, quote unquote, and I say contract, with somebody who does not have the mental capacity to enter into a contract, then there's no contract because one of those 4 elements is not there. Remember, you have to have consideration, you have to have mutual assent, you have to have legality, and you have to have the mental capacity, right? So if mutual assent is there, you have consideration is there, you have the legality, but the capacity is not there, then that is not a contract. It's void. It's a void agreement. So even if you had somebody sign off on this written document, it's void. It has no legal effect at all. When we talk about a voidable contract, it is a contract that could potentially be voided. So if you enter into a contract with somebody, a written document where the person was perhaps intoxicated at the time that they signed it. So there was mutual assent, you went through the offer and acceptance, you have all that stuff. They're generally speaking, they have the mental capacity, it's over a legal agreement, but they were intoxicated and they were not really in their full mind. That's a contract that is voidable. So the person who entered, the vulnerable person, can void it. It has the ability to be voided within a reasonable period of time. And we're going to get into that in more detail a little bit later. An unenforceable contract is a contract where the law does not provide a remedy. So the best example I can give you of that is you enter into an oral agreement for the purchase and sale of a house. I'm going to buy this house. I'd like to buy your house for $1 million. All right, we shake hands. And then the sale doesn't go through. The law does not have a remedy. The law does not provide a remedy. So you entered into this verbal agreement for the sale of real property or the sale of a car. If you don't want to even do it with real property, you entered into a contract for the sale of a car that's, $50,000, but you don't have anything in writing because you cannot enter into an oral agreement over that certain sum. So you did. Well, if you go to court, the court won't be able to enforce that agreement because it wasn't in writing. It goes outside the statute of frauds. We'll get into the statute of frauds a little bit later. So that's the unenforceable contract.
So oral, sorry, so oral agreements are only enforced by the courts up to a certain amount of money, or
Generally speaking, yeah. So oral agreements can be used for, yeah, well, I'll give you the simple answer. Yes. You can't enter into a oral agreement that surpasses a certain monetary amount. You can't do that. It has to be in writing. Different states may have different interpretations, but generally speaking, so this is like the general thing, it's got to be below a certain amount in order for it to be effective.
I have a question.
Yes.
So going back to the avoidable, when you gave that example of
Yeah.
the intoxicated person. So if that was the case, and let's say I was intoxicated and another person was sober, normal, whatever, and then I signed something being intoxicated. Uh, like I'm kind of unclear because I don't like. Can you get out of that? Can you not?
Yes.
You
You
made
can
it
get
seem like
out of it within a reasonable period of time. So let's say you enter the contract at night. You guys were at a Christmas party and you signed over and agreed to something that you normally would not have, or at the golf course, because people go to the golf course to make deals. And so the next day you realize, oh, I shouldn't have signed that. I didn't think about that. I didn't blah, blah, blah. As long as you try to undo it within a reasonable period of time, it can be done.
so is there a specific time
There's
there?
no specific time. It's a reasonable period of time. If you
Shouldn't
wait,
that be a specific time?
excuse me?
Shouldn't that
No, it should not be, because circumstances dictate it. So maybe you didn't even know that you signed anything. You were so wasted, you didn't
Yeah.
even know that you signed something. So if it was like a 24-hour rule, but you didn't even realize it until past that 24 hour, does that mean now you're stuck, bound by this thing? No, it's going to be, again, circumstances and facts dictate. The law, it's all about facts and circumstances and the
Mhm.
patterns and, things that led up to that moment, what happened at that moment, what happened after that moment. So there's no legal
So capacity would be gone because I was intoxicated.
right, but you might not, the point I'm making is you may not know that you
Yeah.
entered into this agreement at that
Yeah.
point in time. So that's why, go back to the underlying thing. You entered into this agreement with somebody. Let's say you were going to be producing, I don't know, widgets for this company, and you're going to be creating or manufacturing these widgets, 1,000 widgets a month for the person you entered into this contract with. You realize, oh, wait, I'm not going to be able to do that because the capacity that we can make is only 800. You're going to call the other side and say, listen, I know I signed this. I wasn't thinking, I was definitely drinking, everybody, saw that or whatnot. We're not going to be able to meet that demand. The other side, chances are they're not going to want to hold you responsible to this particular contract. You notified them within a very reasonable period of time, and they're not going to want to enter and maintain a relationship with you and hold you to this particular contract if it's going to cause problems later on. If you're not going to be able to give them what they want, then it doesn't make sense, right? Both sides have to want to enter into an agreement because there's usually some kind of benefit for both sides.
Mhm.
Does that make sense?
Yeah.
Okay.
Thank you.
You're welcome. So that is the valid, void, voidable, and unenforceable contracts. Now, so everything I just told you, there's actually a theory that goes against all that. And that's the theory of promissory estoppel. So promissory estoppel is a doctrine that allows the courts to enforce non-contractual promises when there has been something called justifiable reliance on that promise, and then justice requires its enforcement. I'm gonna actually give you the definition. I'll put it in the chat. But again, this is in your textbook. And this is a really, really good theory to know in life. Okay? So promissory estoppel, it's a doctrine that enforces a non-contractual promise for which there has been justifiable reliance on the promise, and justice requires its enforcement. So what does that mean in plain English? Who wants to tell us about the case of Skeba versus Cash? Because that case tells us exactly what that is. Skeba versus Cash.
I'm gonna be honest. I saw it on the syllabus. I could not find it in the textbook.
All
Same, I
right.
had to look it up.
Yeah, I
Really?
didn't. I'm gonna be honest. I didn't even bother to Google it. I probably
All
should
right.
have, but I
I
could
could
not find it.
try.
All
I
right.
could-
Did anybody besides Jessica?
I can try.
Okay, go ahead.
Well, Skeba was an employee at Cash's company,
Mm-hmm.
and in 1993, Cash's company experienced a financial problem, and at the same time, Keba received an offer from another company. So Cash didn't want Keba to leave. So Keba said, "If you want me to stay, you have to pay me 250,000." So Cash agreed, and he said he will pay him the money under the occurrence of if the company was sold and if Skeba retired. And over the year, Cash never gave the money to Skeba. So he actually so Skeba sued Cash for it.
You did very, very good. You did very good. Like, there was no written agreement between the two. So you have one entity telling the other, I'm going to leave your company. The employer says, I don't want you to leave my company. I need you to stay. You're one of my top salespersons. I'm going to give you $250,000 if you stay, if we do a buyout. All right. So he had already gotten an offer from another company, the employee. He says no to the other offer. He stays with this company. And he relied on the promise that was given by the employer. He keeps asking him, hey, can we put this down in writing? Can we put this down in writing? They don't. The company now gets sold, and he's like, well, where's my $250,000? And they're like, we don't know what you're talking about. We never had an agreement. We never had a contract. He was able to show through circumstances that he was actually made this promise. And although it was not a contract between them in writing, he relied on that promise. He stayed with them. He rejected the other offer. And so if you were to not enforce that agreement, it would not be justice. Justice would not be carried out. So everything I told you prior to this case would have said, no, you can't enforce it. It's an oral contract. There's nothing in writing. It's going to get thrown out. But the theory of promissory estoppel actually allows that claim to be heard in court and actually enforced. That's why it's important to always have, like, I'm a big proponent of having a good attorney, because a good attorney will know the legal theories that exist to kind of help navigate their client's needs. Very good, Quan. Okay, so that is Skeba versus Cash. That's actually the last thing I want you to know for chapter 9. I'm going to move on to chapter 10. Now, chapter 10 focuses on mutual assent, which is that first element that we talked about, the 4 basic requirements. So chapter 10 focuses on mutual assent. But you know what, before I forget, I do want to do the attendance phrases. Let me see here. I have to write it down as well. Today is Wednesday, March 3rd, 2021. Okay.
You're gonna be giving us the phrase,
Yes,
or
I am. I'm thinking about it, and I also write it down. That way, when you guys submit it, I can actually refer to it. So tonight's phrase will be, I made my son and I a delicious dinner. I made my son and I a delicious dinner. I made my son and I a delicious dinner. Okay. So that is your secret phrase for today for attendance purposes. I made my son and I a delicious dinner. I only have one tonight. My husband took the other one, so that's why you don't have screaming in the background. We can actually get through the lesson today. Okay. Unless he comes home, then we won't do. Okay. So we're going to move on to, let me just save this. Okay. So mutual assent. Mutual assent, again, is the agreement between the parties. It's the core of a contract. It is the heart and soul of the contract. It is the agreement between the two parts, both having them on that same page. So a contract can exist if both sides, whether it's through their actions, through their words, recognize that they're entering into an agreement with one another. It could be spoken, it could be written, it could be by conduct. It is often manifested by the offer and acceptance process. And so what is the offer and acceptance? In order to have an offer, you must have 3 elements. And I'm going to give you I'm going to put that actually in your chat thing here. So take it back. The umbrella of a contract has 4 elements. The first one is mutual assent. In order to show mutual assent, you have to have offer and acceptance. How do you have an offer and acceptance? These are the ways to have an offer. It has to be a communication. There has to be a communicated to the offeree. There has to be an intent to enter into a contract. And it has to be definitive and certain. Remember that thing I said where if I love you forever, it's not really good because it goes on till the end of time. It has to have definitiveness and a timeline to it. That's that aspect. That's being definitive and certain. It's going to start at a certain point. It's going to end at a certain point. So that's the offer portion. And when you break this down, it is communication. And we've spoken about communication before and how important that is. If I make an offer to somebody but they have no idea about it and I change my mind, it's fine because it was never communicated to them. The example I usually like to give is, let's say I'm an employer and you work for me, and you're doing such a wonderful job. You work super hard. You always come in early, you always leave late. And I decide I'm going to give you a raise, right? So you're sitting outside, you're doing your thing. I'm at my desk and I write a letter, and it's on my desk, and I write, dear, people don't write anymore, they email. So it's let's say it's even to make it more contemporary to you young people. I start drafting an email on my computer screen and I'm writing, dear so-and-so, your exemplary work for this company over the past 2 years have demonstrated you as a valuable and important member of this team. Starting on April 1st, I would like to increase your salary by $25,000 annually, and I'd like to give you a $10,000 bonus. I draft the email and I put it into my draft folder. Okay. And then I decide to shut off my computer. Actually, no, I'm going to keep my computer on. You can still see the draft there. It's, still marked draft. And I decide, what, it's Friday. I'm tired. I'm going to go home. Because you're such an exemplary employee, you still work after 5 o'clock. I leave my office. I say goodnight. You come in to leave me some files for me to look at Monday morning, and you happen to look at my computer screen and you see this letter that's meant for you. And you're like so excited. You're so happy. You then decide this is going to be a great weekend. You're getting a $10,000 bonus. You're getting a $25,000 salary increase. You go out on a major shopping spree. As a matter of fact, you've been eyeing this wonderful car. You decide to go to the car salesperson and put a deposit down, and you walk out of there with a brand new, what can $10,000 buy? Maybe a Tesla? Can it be a down payment for a Tesla? We'll say it is. And then you come Monday morning, you're super excited to start work. You greet me with a hello, boss. And I'm like, why are you so happy? We just lost our biggest client over the weekend. I sit at my desk, I see the draft, I delete it. You ain't getting that raise. No raise, no lump sum payment, no nothing. The day continues by, you didn't receive that email. what do? Do we have a contract? Do you have a claim against me?
No.
Nope. That whole big scenario I gave you, Jessica answers with one word, no. There is no agreement between us. Why? Because, why, Jessica?
Because it was never communicated to you. You saw it without really having it been offered to you.
That's right. That's right. So I could think all I want in my head. It was not communicated to you. Therefore, it's not going to work. You can't come to me. There's no justifiable reliance here. We never had that agreement. We never had that conversation. It was never communicated to you. So that first of the three elements of an offer, communication, wasn't there. Clear, everyone? If it was in class, I'd actually be able to see all your little heads and you would be bopping them up and down. So I only see 3 heads, which is good. I'll take it.
Sorry.
That's okay. That's okay. That's the life that we lead nowadays. Okay, so that's the communication, manifesting an intent to enter into a contract. Again, it's that conduct that you would have that back and forth, right? It's the I want to enter into a contract, you want to enter into a contract. It's us kind of talking it out, going back and forth. And again, that's, that's I think that's kind of a clear thing. I mean, it's, what would a reasonable person infer based on the circumstances? If I say to you, I'm going to sell you the Brooklyn Bridge for $1,000. That's a joke. I would hope you would recognize that that's a joke, right? So that can't be, negotiation back and forth because it's not credible. It's not part of that back and forth, that intent to enter into a contract with one another. And then the last element is the sufficiently definite and certain. Again, you want to be able to have a definitive end game, definitive beginning game. You want to have that finality to it, and so you're not questioning whether or not these terms are clear or not clear. So that's the definitively certain and definitive. Let me just see here. When we talk about preliminary negotiation and advertising, they're not really considered offers. So when you see an offer on a magazine or like a flyer or a circular for, I think we might have mentioned this in this class, I can't recall, for Black Friday. Or now it used to be like Black Friday, it was just a couple of hours. Now it's an entire week, and now it goes into an entire month sometimes, right? If you were waiting to make that purchase of that gigantic big screen TV for like $100 and you're like, oh, I'm going to get that. You wait online, you're the third person in line, you go into Target or Best Buy or whatever, and they tell you they're sold out. You're like, what the hell? I was the third person in line. But meanwhile, underneath that caption where they have that big screen TV with the $100 price, you know what they have right underneath it?
Says until supplies last.
Ding, 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 while supplies last, and their supplies maybe just 2. So, it's an offer, it's not a guarantee. You can't say I justifiably relied on that advertising and that's why I actually stood there, or slept there all night long to get that, because that fine print says it's only there for a limited supply, and it's not, advertisings are not considered an offer and an acceptance. Let me see here. What else? So with that, the case of Lefkowitz versus Great Minneapolis Surplus Store, that case actually talks about advertising. So who wants to tell us about that?
I can.
Thank you, Carmen. Go ahead.
There was this dude. He saw an ad for, I believe it was fur coats that were worth $100, being sold for $1. And he arrived at the store. He was like the first customer there, and they told him that they wouldn't sell it to him because that offer was only for women. He then later saw another ad saying something about selling mink scarves. He went back. They told him the same thing and kicked him out because they said he knew that rule. And then he sued them, and I don't remember if he won or not.
All right. I don't even care actually what the end result was on this particular case, because I think he won with one thing and he lost with the other. The point is, advertisings are, they actually had to honor him at one point, because they put an out, there was no rule that was written down that it was only for, women and not men. And he was the first person online. He was able to get it. There's really no reason for them to discredit him for not being there. There was nothing that would have suggested that he would not have qualified. I think Karma, I think your cat wants to be in this class. I love that. Your cat's like my kids.
She won't leave me
Uh,
alone. She's
that's
coming
all right.
back. I see her coming back.
See, that she can join. That's all good.
Mine
Maybe she'll get
opened
some-
my door too, so don't worry. Mine's
Yeah.
harassing me as well.
That's okay. Well, I'll try to move this along, guys, so you can go to your feline companions.
Yeah, I'm just gonna keep throwing her on the bed. Whatever.
All right. Don't hurt the animals. Can't have that. We're being video recorded, okay?
She'll be fine.
Thank you. Definitiveness. So that's basically, that case is really just about advertisings. Advertisings are not offers. So you can't expect that whatever is in the offer is going to be there. Most stores will try to honor things as long as it's not going to like totally screw them as far as prices are concerned.
Wasn't there also a case a long time ago with Radio Shack getting in trouble for bait and switch advertisements where they were advertising
Radio
one thing?
Shack or
I think it was Radio Shack.
might have been.
I think it was Radio Shack. I heard something about that.
Yeah.
I forgot
I
the
remember that.
specifics, but they were basically advertising one thing, and then it was like whatever they were offering, it wasn't for that item, it was for something else. It was just to like get people in the door.
Get people in the store.
And they were held liable for that, I believe. They did get in trouble, and that's like not allowed at all anymore.
Yeah, there's actually things that I think changes to the law or changes to how consumers view things that are based on situations like that, because it's not honest. It's not, that's why like you'll have now on the offer, the flyer, while supplies last, they'll put the fine print. I mean, you might need a magnifying glass to see it, but at least it's there. But it's essentially, I did not know that I could pause the recording, and it had this big red button that showed up, and I kind of freaked out because, all right, sorry. Okay, let's just see what we have here. Okay, this is a listening thing, not a write it down. Sometimes, depending on the relationship, the contractual relationship, the definitiveness might not be a necessity when you're talking about like one company with another. When it's more of a commercial thing, you can actually have open terms in a contract, and the contract would still be valid, because it may just depend on the nature of the agreement and the relationship with the companies. So if you have like a restaurant, a seafood restaurant, and they get their seafood from a fisherman, and they basically buy whatever the fisherman catches, they will purchase that. They don't have a specific amount that they say, well, we're going to buy, 5 pounds. They can just say, I'm going to buy whatever output you have. There's actually a name for these types of contracts. So there's something called an output contract, and there's something called a requirement contract. And an output contract is an agreement of a buyer to purchase the seller's entire output for a stated period. So this restaurant can say to this fisherman, well, we want your entire output. It's going to be an output contract. So whatever it is that you are able to pull from the ocean, we're going to buy from you. Requirement contract is kind of like the opposite. It's a contract where the seller, it's an agreement of a seller to supply the buyer with all of its requirements for certain goods for a certain period of time. I think the output contract is more something that you see more often. So I'm going to ask you to know. I'm not sure if I'm going to test on it or not, but I want you to know what an output contract is. So I'll put that definition for you in the chat. So just kind of, make sure that you put that in your notes. Let me just see here. Okay. All right. When we also talk about, still, this is all within mutual assent, and we're talking about the offers and acceptance. So I make an offer to you. You can basically accept it until it's terminated. So how can it be terminated? Either by acceptance or, what other way can an offer be terminated? There's actually 7 ways that an offer can be terminated. So the offer can end by acceptance, but it can also end by these things. Again, this is all in your book, but I'm going to also put it in your chat for you, and I'm going to explain each one. So you can make an offer. I offer to sell you actually, I'm going to give you a real example. Houses on the market. Now, this is not really UCC. It's not particularly, it's real estate, so it's a little bit different than personal, goods. But a house is on the market, right? It's on the market for a certain period of time. It could be then removed. So if you remove the listing, it's no longer there. If I make an offer to buy a particular home, it can also be, I can revoke my offer. I can say, you know what? I gave you my offer last week. You have not responded. I take my offer back. It can be rejected. So the person that is owning this particular house can say, thank you for your offer, but it's not good enough for us. We're rejecting it. They can make a counter offer. One of us can die, and so then that agreement can't be binding. That offer can't be binding. The house can be destroyed. That house can be destroyed. Therefore, if the subject matter is destroyed, the offer is automatically kind of withdrawn. Or at some point it becomes illegal to sell homes, and so in that case also that offer is no longer there. So those are 7 ways, in addition to acceptance, where once you make an offer, it can also be terminated. If you've ever watched the show Shark Tank, anybody? Shark Tank? No?
I've seen it a bit.
Thank you. My son watches it. We watch it as a family. And so you have a lot of it is the offers and acceptance and the counter offers, and whether or not, it's going to be a wonderful idea and you're going to be a millionaire or not. It's going to be a loser idea. So in that show, actually, they do a lot of the offers and acceptance, and then that is translated into a contract at some point. Does anybody have any questions about any of the stuff that we spoke about so far? Okay. The next case we're going to talk about today is Sherrod versus Kidd. It's kind of, I think this bears on real life also. Who wants to tell us about Sherrod versus Kidd? Anyone?
I might be crazy, but I don't think I see that in
On the
the
syllabus? Maybe I took it
syllabus.
out. I'm really I'm very nice. I've taken a lot of stuff from you guys. I did take it out.
Yeah, the next case was Neubauer.
All right. Yeah. Neubauer and Reed versus King. All right. Well, I'm going to tell you anyway about this is for fun life because it's a good case to know. So in Sherrod versus Kidd, there was a lawsuit going on, and the parties actually went to something called arbitration. So arbitration is instead of going to the judge, both sides will decide to go to an arbitrator, which is a third party, and then whatever the arbitrator says is binding, it's kind of like binding. So you're not going through a trial, which could be, usually a lot more expensive than actually going through an arbitrator. So before they went to the arbitrator, one side offered the other side, let's settle this case for $32,000. The other side never responded. They never responded. They offered them the $32,000 before they went to arbitrator. That way they wouldn't have to keep going with the case. They could just settle it and move on with life. No response. They go, the arbitrator awards $25,000, and an arbitration is binding, right? It's as if the judge had made a settlement. So then the guys that won the $25,000, they go back to the other side. They're like, you know what? We'll take that $32,000. So the other side's like, no, we gave you that $32,000. You didn't respond. Therefore, the time for you to have accepted it has passed. So that's the lapse of time issue when we talk about offer, acceptance, like the time has passed. You went through the arbitration process. This was just an offer of settlement, so we can kind of move on with life and not have to go through that. So that kind of case just talks about the lapse of time and how that's kind of displayed. Talked about all that, rejection, blah, 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 death, okay. Okay, let me just take a look at the syllabus here. Okay. All right, so I will just move on to chapter 11 then. Does anybody have any questions on any of the things that we spoke about so far? No?
Good.
Okay, thank you. So we are going to move on to chapter 11, which is conduct that invalidates assent. This should ring bells to you. And it's kind of like when we talked about wills and when a will when it could be kind of thrown out, when we talk about undue influence and fraud and duress. A contract has those similar attributes to it. If somebody had entered into a contract based on undue influence, duress, or fraud, the will is not the contract is not good. It can actually be tossed out. Why? both parties did not enter into it willingly. So if one side is forcing the other to sign this document and agree to this, and it was not something they wanted to do, it could be invalidated, right? It's voidable, and it could be thrown out. Let me just see here. The case that we have here, which is really an awesome case. I usually test on this case because I love it so much. It's Neugbauer versus Neugbauer.
Can I talk about this one?
Sure. Does anybody, because Carmine spoke, Jessica spoke, and does anybody that hasn't spoke today want to tell us about this wonderful case that I always test on because it's so cool? Okay, Carmine, it's all you.
So there was this couple in the 80s, the Neubauers. They owned a farm, and in the 80s, the husband died, leaving the widow Pearl the farm, and he had always handled all the finances. And they had, I think, 7 kids, and 2 of them started farming the land, and they were paying Pearl the rent. And part of the agreement was that she could sell them the place for the appraised value in 1984, which was like $117,000. They stopped farming together, and only one son, Lincoln, kept farming the land, and he kept paying the rent. And eventually, I think in the mid 2000s, he bought the land from his mother, but when he sat her down with the lawyer, they didn't make her aware that she was allowed to have her own lawyer there, and she didn't understand anything that they were talking about. And they ended up selling the land for, or she ended up selling the land for $117,000 without knowing that the current value of the land was more like $650,000. And he told his siblings not to mention, or he told her not to mention anything to the siblings. When she did, they told her that like he screwed her over, and she took him to court and she won.
Excellent. Excellent, excellent, excellent job. You hit every single point I wanted to make. Shame on Lincoln for trying to screw his mom, because that's basically what he did. He took her, the poor woman had very, very limited education, which is something that the judge touched upon. She had no idea what was going on when she was in that attorney's office. They basically were like, hey, sign this. She and the icing on the cake was when he told her, don't tell any of my brothers and sisters. So once he said that, she was like, something's not right here. And then when she told him, she got so upset when they told her, like, Ma, the land is worth like $700,000. She called up Lincoln. She called him on the phone. She's like, how could you do this? Rip up this document, rip up this contract. And he's like, no, Ma. And then they had to go to court. So it was mom against son. And the mother won because there was what? It was undue influence here. Okay. There was, mom had no idea what was going on. She was totally taken advantage of. So great job, Carmen. That was very, very good. Okay. Okay, great. So the next, let me just look at the syllabus so I don't actually ask you a question. Okay. So fraud. Fraud is also a thing that can obviously invalidate a contract. So fraud can be construed in 2 different ways: the execution or in the inducement. So if you tell somebody, hey, this is I need you to sign this piece of paper so I can do this thing, I just need your quick signature here. Meanwhile, you're getting them to sign a contract between you two, and they thought they were signing a wireless bill. That's fraud. That's fraud in the execution. The actual execution itself was not right. And if you do fraud in the inducement, it's a misrepresentation of an essential element that's necessary. And the next case that actually talks about that is, let me just see here. This is also a really fun case, Reed versus King. Who wants to tell me about Reed versus King? Hold on, let me find it.
I can do it if no
Tell
one
me.
else wants to.
Go, go, go. I love that case too.
Okay, so with Reed versus King, Reed was looking to purchase a house. King was looking to sell. However, there had been a murder in that house, which both the owner of the house, King, and the real estate agent were aware would have affected the value. However, they presented the house as being in great condition and basically did not talk about that whatsoever.
And how many people were murdered?
I don't remember, to be honest.
It was 4. It was an entire family.
Oh. So, so they had also asked like the neighbors to not tell the buyer, Reed, about what had happened. So they ended up selling the house. I think it was for like 75,000 when the house was only really valued for like 62.
Because of the haunting, yes.
And then once once Reed had moved in, the neighbors actually did inform them of the event that had happened. They went to court saying that they had not been properly informed. I believe originally the complaint was dismissed. Reed then appealed, and the judgment was reversed. And they, because it was such a horrific event, there really was that should have been a consideration for Reed to have made.
Exactly. If he had disclosed that there was in fact a murdered family there, and the purchaser still wanted to make that purchase, if they knew about it, then that's totally fine. There's no problem. The reason they didn't disclose is so they can get a higher value for the house. The reduction in the value was based on the condition, the fact that a whole family was murdered there. So again, it's fraud. The fact that the owner of the home told the neighbors to conceal a fact, that was the problem. Even if he did not conceal that, if he did not proactively try and conceal the fact, and then the homeowner made that purchase, the case might have not gone their way. But because they took an active step to conceal, that's where the problem is. You got to kind of put it out there. I'm maybe because I'm an attorney, I like Google, like research everything and anything, get as much information publicly that I can about certain things, right? So if I'm looking to buy something, I'm looking up to see who the owners are, what they've done in there. I'm looking up their it's like stalking Instagram accounts, their Facebook pages, whatever, because people are putting it out there, right? So if it's for me to see. And so if you are trying to actively conceal something, a fact, that can go towards fraud, and that's not good. You don't want to do that. People should know what they're getting into, and then they can make an educated, informed decision about whether or not they want to proceed. Any questions? Great job.
Isn't there a legal obligation to disclose if a murder's in a house now? I don't know if it was because of this case, but I'm pretty
I
sure
don't
there's a
know.
legal obligation.
I don't know. I'm not familiar with, so I can't comment on that. Everything now is so public. I think like a simple search on the internet like would, really disclose or make, help you find things like, even if it wasn't a particular murder, right? Let's say you had an infestation, like a termite infestation or leaking, and you painted to try to cover it up. That might be construed as you trying to conceal fundamental damage in a house. However, the burden could also be shifted and say, well, listen, you are buying this home. You should have gotten an inspection. If you had gotten an inspection, it's on you, right? That's why I'm a big proponent. If you're buying a piece of property, get that inspection, pay for it, find out everything that's wrong with it, and that way you can make that, informed decision. Let me see here. What else do I have to tell you guys? Blah, blah, blah. Okay. Let me go back to okay, unilateral mistake, assumption of risk. When we talk about unilateral mistake, don't even worry about that. Like it's not really something that I'm going to go over with you. The last thing I want you to know about this chapter is assumption of risk. Assumption of risk, you've heard the term before when we talked about negligence and skydiving. Assumption of risk can also be with contract. If you go and you buy something as is in a garage sale on eBay, that's final sale, you buy it, it's as is. It could work. It could be an antique worth $1 million, or it could be a dud, right? You're taking that chance. You're not getting any warranties. We're going to talk a lot about warranties a little bit later, but you are purchasing it at your own risk. So you can't expect it to perform or function in a certain way. So that's assumption of risk when it comes to actually contractual obligations. You can make it big, or you could have a piece of junk that you end up throwing out. That's what happens when you buy things at, garage sales.
That's like when you watch like Storage Wars and stuff.
I love that show. Yes, it is, exactly. I feel like I want to say that all this stuff is real, but everything I read says no, it's all staged. But I'd like to think in my heart of hearts that maybe one day I'll go out and buy a storage and it'll be filled with millions of diamonds and things of that. But why would you keep it in a storage like that if you had all these diamonds?
Yeah, we can all dream.
We can all dream. Yes, it's the dream. It's the dream that kind of keeps us going. So that's it for this evening. Does anybody have any questions about anything we covered so far?
Yeah, just one question.
Sure.
So you see those 7 things that you wrote in the chat, lapse of time?
Yeah.
I didn't get what were those 7 things were like. What are those for? Those 7 things.
Terminating an offer.
Terminating an offer. Okay. Thank you.
You're welcome. And again, as always, I will post this on the YouTube, and then I'll post it on Blackboard.
Those are very helpful, Professor.
Okay, good. I'm glad. So you'll be able to watch it and learn doubly. So if you missed anything tonight, you can watch it again later. And if there's no questions, we can conclude for the evening. Have a great night, everyone.
Have a good night, Professor.
Yes, we
Take
did
it
the
easy.
attendance
Thank you,
statement
Professor.
already. So
Have a good night.
good night.
Good night.
Professor, I got a question.
All right. It's not about the statement, the attendance, right?
No, it's about the test.
All right,
I
go
was
ahead.
the one who texted you. I mean, emailed you during the test.
Okay. I
So
don't remember, but go ahead.
he said the one like I was doing the test and it closed down, then you open it again.
Yes.
So like I did.
I went to your exam. You did not start it from the beginning the second time. You did start it where you left off. So that's why I took your first grade and your second grade. It ends at 9:15. So, regardless of where you are, I stay up and I watch it and I make sure that, all the students are progressing. So it ends at 9:15, regardless of when. You were the only person out of my 95 students that had that problem. So
Actually, because like I'm like in another country and like the
right.
service not good here. Also, like